Okay, we're here today with a special report on the family courts and family court corruption and what certain people are doing to expose and combat it. And I have with me today two very special guests. Uh, the first is Jill Jones Soderman, and she's the executive director of the Foundation for the Child Victims of the Family Courts, as well as a man named Theo Chino, who is a legal management consultant and a family court accountability advocate and expert. And we're going to talk a little bit about accountability in the family courts and judicial conduct. And a little bit, we'll get a little bit into systemic reform. We're going to focus on accountability both legally and financially. And the focus of this discussion is really uh, an informative, more of a educational driven, I guess, survey of the landscape of the family courts. And that's why I brought Jill and Theo here to tell a little bit about themselves and what they do. And we'll get into some of the issues that litigants face in the family courts when they go up against the system. So,
Mhm.
Jill, we have you here. Love for you to say hello and tell us a little about yourself and about the foundation.
Thank you so much, Richard, for this opportunity. I'm the executive director of the Foundation for Child Victims of the Family Courts. We have been a 501c3 nonprofit whistleblower organization for the past 23 years. Our work is involved with supporting through litigation and prosecution of alleged crimes of fraud and collusion in family court, uh, high conflict custody litigation. Our mission is to help support protective parents in the process of securing the safety and protection of the children and that of the protective parent. Our major concern at the moment has been the undermining of confidence in the public that there are remedies to the profusion of issues related to family court corruption that are seen as the court is invincible, that there is no protection for protective parents in the courts, and no realm of protection for their children who are being handed over to abusers.
So
Uh,
Jill, let's take a
yes,
step back. Your
yes.
your foundation is both an educational and a watchdog type group. You provide education, you provide resources, you provide a watchdog eye on the family courts. Tell us how you got into this, and tell us how the foundation started, and then tell us what the foundation does on a daily basis.
The foundation began actually in about 2002 when I was basically an advocate for a family while I was working I was doing some volunteer work at a local charity at a domestic violence shelter. And one of the parents came forward and asked me if I would see her children and see if I could be of some help to them, that they had been severely traumatized and abused by their father, who was a very wealthy and powerful individual, and who was had been able to just destroy their lives over a period of years. They were left homeless. They were in a shelter, and they were about to be in family court seeking protection of the children. I came into court into support for them simply as an unpaid advocate and as a consultant to the domestic violence shelter. As to the domestic violence shelter, I was the clinical supervisor for them in West Milford, New Jersey, where I was, my function was as a psychoanalyst and family therapist, and just support for litigants, for protective parents there. When I came into the case and became involved in a very supportive manner of the children, I was able to secure their ability to move from New Jersey to family in Kansas to to complete the divorce process of the mother with the children and to secure their protection.
So Bill, it's fair to say that you were a court insider. You were someone who was called in by judges. You would testify
Yes,
before. You've worked with the family courts, and so in 2002, you decided to change gears, and you just said, you know what, the foundation, the work that you do needs to be done. Nobody's doing it, and
right,
it's almost, what, 23, 24 years later, and you're doing
right.
that work. Now, explain to us what the work is. I know that you do
Well, let me just
educational, you
back
do
up for a
hospital.
second.
Okay.
Let me back up for a second. So, having secured the safety and security of the children, and they were about to move to Kansas, um, the perpetrator of harm against these children, who was a very, very wealthy individual, secured the services of a court-appointed psychologist by the name of his name Dasher, Paul Dasher.
Okay.
And Paul Dasher was a court-appointed, um, covered by immunity individual who brought out the concept of parental alienation uh, against the mother. The To make a long story short,
Tell us real quick, Jill, for the audience, what is parental alienation?
parental alienation is specifically a term generated by Richard Gardner, MD, who was a forensic psychiatrist who developed a marketing program to support his work with men who were charged with incest. And this was in approximately 1983, but his work began to be popularized in the late 70s and early 80s. Parental alienation, the concept as per Gardner, which Gardner's concept was a debunked concept that involved that the sense that children were sexual predators, that they were born with sexual drive, and that they initiated sexual activity with adults. It was a bizarre, psychotic
This a
concept.
is this a psychological theory? Is it a legal theory? This term parental
It's
alienation is a very hot button issue. What
right.
is it? Is it something else?
It
What is
was
it?
a marketing concept developed by Gardner to promote his forensic practice. The the concept then was picked up by the bar associations across the country and weaponized as a concept that supported plausible deniability. And deniability that whether or not the question arose whether or not there was actual sexual abuse, and that the charge was that the parent bringing the claim and the child bringing the claim were both liars and looking for an advantage, a false advantage. And the concept then was empowered and weaponized by bar associations, which introduced a concept that involved deniability, that cast doubt on the motives of the protective parent. So the protective parent, men and or women, were then accused of falsifying their allegations, using the children as a means of gaining a personal advantage. This was not true. Children are not sexual predators. Children are not liars. Children do not look to um, engage adults in sexual activity. This is a psychotic concept.
So, Jill,
It's
you said
promoted.
that it's a marketing gimmick by Gardner that was turned by trial lawyers into a legal tactic. But there are others
Exactly.
out there like Linda Gottlieb and others that are proponents of parental alienation.
Right. Right.
Those parental alienation has been debunked, as you
Right.
allude to, by the UN and by other groups.
Right.
They think that there's strong evidence, even in the DSM, the signs of
Right.
parental alienation. How
Right.
do you respond to that?
Well, first of all, in terms of the DSM, I was active in participating uh, with the DSM two at that time, when I was part of Columbia College of Physicians and Surgeons Psychiatric Institute, and we did a great deal of work in developing the codes for the DSM around depression, around different various kinds of diagnostic issues. So the whole issue of the process of creating a DSM diagnostic issue involves extensive interviewing of thousands and thousands of people, of dealing with scales, of very technical diagnostic processes that take years to develop. There are teams of experts who are trained in presenting the technical material, the interviews that are both written and personal interviews, dealing with thousands and thousands of people and committees.
Is parental alienation junk science in your opinion?
It is beyond junk science. It is a criminal enterprise that is entrapping parents, protective parents, destroying the lives of children and the credibility of children, and disseminating false and misleading material.
Sure that we're going to get
for financial advantage.
I'm sure we're going to get comments to the contrary, but we'll
of course
we'll close on that with parental alienation. But what we're getting for is a lot about the corruption of the courts and how we track it down. I'm going to move over to Theo Chino real quick, and Theo Chino is a brilliant guy. He's a legal management consultant, and he is actually involved in doing the work of billing, actually, and that's the core of the family courts, and that's the core engine of that drives the lawyers. And he does a great job reviewing legal bills and finding not only inefficiencies but finding actual legal violations. So Theo, can you tell us a little bit about yourself, who you are, what you do with respect to the family court? And I know you're on mute right now, Theo, so you can unmute yourself and start talking.
Sure. So thank you for having me on. I will start off by saying, first of all, I am not licensed to practice law in Illinois, and nothing I say is legal advice, and nothing I will ever say is good legal advice, because there is no such thing as good legal advice. People pay hundreds of millions, maybe billions of dollars for legal advice and legal representation and all this BS. And they're usually paying someone to mess their lives up even more. That's what I found. Now, that's the big picture, right? So now I dig into what I do. One of my heroes is Peter Falk's character, Columbo. And all I want to see is the bills and the fee agreements. I'm not licensed to practice law. I tell everybody I'm nobody. I'm nothing. I have a degree in finance. I studied the classics, which helped me to understand family court a lot, because the classics also taught me about the ancient gods and hubris and all these other little games people play when they play gods in other people's lives. And finance, hey, things either add up or they don't. They either make sense or they don't. So I don't want to ever get into, I really try to stay out of what happened to dad, what happened to mom, what's going on with the kids. I try to stay out of that, because I feel like unless I am living in that house for 10 years with those people, I would never understand what's really happening. But what I can understand is this.
Yeah, Theo, you follow the money, right?
Yeah, I mean, what I do is ask questions, right? So one thing I definitely do not know is what someone who practices, air quotes, family law would say in a billing rectification conference that's on a Zoom recorded call. Do you know why I don't know what they would say?
Why is that?
Because not one of them have showed up to explain their bills per their ABA model rules, per the RPCs, the rules of professional conduct. Not one of them have showed up to explain their bills. Do you know what they'd rather do?
Stop there a second, Theo.
Yeah.
Lawyers have rules about billing? Tell us about these rules.
Well, you can look them up. You can Google them. You can go to your favorite AI and ask about.
They can't just make it up. How does it work?
Well, they can if you're okay with it, right? I always say nothing's illegal if everybody's happy, right? I mean, if you're super happy with your lawyer and they made you feel good and you walked away relaxed with more money in your pocket after you dealt with a lawyer, I guess whatever they did was okay, right? You're happy. When you're not happy, and you start looking at how they served you, the advice they gave you, how professional they were, they weren't, and then start looking at their bills that they issued, oh boy, what an adventure that becomes. So there are American Bar Association rules. I didn't write them. I am not some sort of senator. I am not licensed to practice law in the state that I live in, but I can read rules, and they're pretty simple. And they actually say something like, these charges need to be found to be reasonable. Don't quote me. Just look them up for yourself.
And we'll get into some of the bigger issues, but I want to just give an example to the audience. So you'll look at a bill, and you'll look at a family court bill, and then I've seen some of your work where you generate a report about the billing, and you actually have codes about what the billing is and the discrepancy billing, and then you have rules of professional conduct that are next to those codes. What are the big ones that you have there? I know that you've talked about administrative expenses that shouldn't have been charged, double billing, things that are unreasonable. What are the types of codes that you find when you examine a bill?
Yeah, all we come up with is questions, right? I never say, you know what, this bill is fraud. You are a liar. You owe this person money. I don't say that at all. All we do is we analyze the billing and we look for whether or not they meet. So there's an algorithm that I've helped to train and develop, and it looks for things that need to be explained further. And then we say, hey, we have questions about this bill. We recently had a woman who was being hounded for $6,000 that she didn't have. And she called me up all worried. And I said, well, let's take a look at the bill and let me see what I come up with. And the report simply said 80% of this bill needed to be explained. So she's like, should I point at them? Should I tell them they're going to jail? I'm like, no. Just tell them that you have a report that says that his bill, 80% of it needs to be explained. He says to her, I don't agree, but you know what? Just pay me $1,200. 80% discount right off the bat.
That's out of control. So I'm going to go back to Jill because you raised an issue, Theo, and we'll get back to you on it. But that
Sure.
issue is called strategic embellishment. And this happens a lot in the family courts. And Jill put out a recent article, and she described how the family courts engage in that pattern of strategic embellishment, presenting facts in a way that stretch the truth. Well, technically, they stay within the legal bounds, but they're stretching the truth. Jill, tell us about this and how you see this culture of bending the truth play out in the family courts, and what impact does it have on parents and children that are seeking justice?
Well, it goes back to the fundamental issues of plausible deniability, that attorneys can argue both sides and create a representation for the abuser and for the protective parent. And they can argue both sides, making the substantial intellectual properties involved in diagnosis and in evaluations fungible, questionable, as if they're gray areas. And they're not. They're scientifically based, but they can be argued about. You can't argue about legal billing and numbers that don't match the services provided or the services requested. The legal billing also provides insight into conversations, interactions, or failure of following up on critical legal issues involving transcripts and interviews.
I'll tell you something, and the billing becomes a Rosetta Stone. I've covered a lot of stories about this. One of the most famous ones is one that Frank Parlato and I have covered about a guy named Ed Nussbaum up in Westport, Connecticut. That's related to the Karen Riordan and Christopher Ambrose case. Ed Nussbaum billed an outlandish amount of money.
$25,000.
He billed over $100,000.
Well, one bill was $25,000.
Appeared in court once, filed one motion, and billed over $100,000. But when we took out the bills, what did it have on it? It had his conversations with a guardian ad litem. Jocelyn Horowitz. And she was the guardian ad litem, and she had to submit her billing to the court to get it approved. And when we took the court-approved billing that Jocelyn Horowitz submitted and the time that was in there that she had conversations and telephone calls and emails with Edward Nussbaum, and we compared it to Edward Nussbaum's billing that he tried to sue his client for, Nussbaum inflated it by 3 times.
Right.
So we have the court saying that you've spent X amount of minutes, doing this on the phone and this on an email, and the court agreed to it, and the guardian ad litem swore to it, who's an attorney, and then you have the lawyer overbilling 3 times for the same amount of work. And so one of those two can't be true. And I would think that people would side with the judge who had already gavelled down on what the guardian ad litem said, as opposed to the bloated 3 times bill. Do we see this a lot in the family court where there's these bloated bills?
Well, Richard, let me tell you, on the Nussbaum case involvement with which was the Ambrose case, the Riordan case, Riordan was our client at the time. And one of his email communications to the mother, to Karen Riordan, was, pay me $25,000 and I'll get you a motion for a court appearance. There was no court appearance prior to, with all of the billing of thousands and thousands of dollars of billing. She'd never been in court to even begin to argue her case. When we came in and said, there needs to be a court appearance dealing with this, that, and the other thing, his response in writing was, pay me $25,000 and I'll get you a motion for a court appearance. The billing is out of the peripatetic imaginations of the attorneys involved. And we see this all too frequently, where a protective parent is at the mercy of the court, because the judges have both discretion and immunity, both of which can be pierced and prosecuted under the right circumstances, under the intellectual, scholarly legal work of attorneys who are willing to confront these issues. That's a whole other area. But
so, Jill, I want to ask Theo about the same thing.
But it was Theo's our ability to involve Theo that there was then a hard structure as to how to attack the intellectual property.
Yeah. So Jill,
which is the Bar Association.
Jill, Frank Parlato and I both wrote big articles about Nussbaum detailing the bill's problems, but from a journalist perspective. But Theo, tell us how you would handle a case. You could talk about a specific type case that you've handled. You could talk generally about a case, but if you had a situation where you have a guardian ad litem billing that was submitted to the court, and then you have billing from an attorney to the client that does not match in the slightest, how do you handle a situation like that in your analysis? What would the steps be taken that you would do?
Well, see, that's the thing. A lot of people are too traumatized, too clueless, too scared to even question people that look like legitimate authority figures, right? They're too ashamed. Maybe they're guilty about something else going on in their situation. And this is the time for predators to pounce, right? So no one would have the wherewithal, almost no one would have the wherewithal to say, wait a minute, guardian ad litem charged for 45 minutes here to talk to, I'm sorry, notorious, there's no other nice way to say this, notorious scumbag overbiller over here who bills for everything. In fact, his first name is Bill. And this guy does not record this phone call, but the guardian ad litem charges for 45 minutes, ending up charging $50,000 to represent 2 children who had 0 physical or mental or emotional issues. And now we have a blatant act of exposed fraud. What do? You would think a state's attorney would be salivating, slobbering to get at this person, right? This person, this GAL, used to work for the state's attorney's office. So does the other attorney. I feel like the stories I've heard about Poland right before World War II, I feel like our families are poor little Poland, and you have 2 sides going, well, we'll meet in the middle and we'll just smash them up. we'll just eat them alive. And the poor little families can't stop it.
Yeah.
There's another dimension to this also, which involves the flow of federal funds to the states under Title 4D and Title 4E.
So this is a huge feeding trough, Jill, is what you're saying.
Right.
But when you get into family court, they look at you like cattle. They're looking at what's the best way to get you into the slaughterhouse.
Right. Exactly. That the money is a free flow largesse driven by judges who can file for grants under Title 4D, under Title 4E to protect children and families that are subject to domestic violence and crimes. So by supporting the person who comes into court and is named as the abuser, and then redefining the abuser as the protective parent, the court becomes the hero, the heroine of the new protective parent, transferring the child from the protective parent who is accusing the abuser of abuse. The court says, no, we have new evidence. We can show that this person who's making the claim is doing it for fraudulent reasons, and that person is a liar, the child is a liar. And we're instituting all of these programs, the psychologist, the parent coordinator, all of these different, the mediator, all of these different levels of professional intervention that are meant to disqualify the charges of the protective parent, to debunk hardcore medical and psychiatric evidence, and stripping the child of any autonomy or any ability to protect themselves, as well as the protective parent.
Let's talk about that real quick, Jill. Let's take a step back to the audience.
Yes.
You talk about Title IV, and there are different areas in Title IV.
Yes.
Title 4B, Title 4D, Title 4E, but they basically relate to federal funding in different areas related to the family courts. So you have Title 4D you have things about collection of child support. You have domestic violence type stuff under the Violence Against Women Act as well. But while they were well-intentioned federal programs and federal monies, a lot of times
very effective.
They're being used by the state courts as budget fillers. So they need to hit, quote unquote, an unsaid quota. So they put everybody into either domestic violence or unpaid child support. Adoptions are a different issue with Title 4E and foster care,
which is another source of fraud.
So, and we'll get into that. That's a bit far afield for what we want to talk about, the specific billing. Right. But bringing it back to the billing issues, part of it has to do with an insular family court culture. And I'd ask you a little bit about that, Jill. Family courts are known for giving judges broad discretion, right? And they operate with a lot of off-the-record dealings.
Right.
And there's a professional familiarity with the attorneys, with the court appointeds, with the evaluating therapists, with everybody else.
Right.
And so in practice, these informal relations, also CPS, which we're going to get into yet.
And the police.
And the police. And reputation sometimes outweighs the black letter law, and it outweighs, the expectations of what would be done in determining the outcomes.
Right.
How does this culture contribute to the lack of accountability? How does it add to judges looking the other way, allowing or permitting lawyer misbehavior? And do you believe that the answer is a greater transparency?
Prior to 1983, 82, 83, judges behaved with integrity, with a level of concern for family privacy, confidentiality. There was a respect for the sensitivity of material that was that was being imparted in the courts. Incest, abuse, horrendous kinds of crimes, but there was a level of wasn't perfect, but there was a level of integrity and respect. Judges
What happened in 1983?
it was Gardner, the whole concept of Gardner's marketing plan and the arrangement between the bar associations across the country developed in connection with the AFCC, the Association for Family Court Conciliation Services. That was a marketing drive that brought together, which was a wonderful idea. It was a wonderful concept in its inception, to bring together judges, experts, medical, psychiatric, psychologists, to work together to understand the nexus of reporting, of understanding who was making false allegations, what the diagnostic issues were, and the privacy issues. And this worked very, very well. I was a private consultant to judges, and there was a level of really deep personal concern
So you believe
and
that
protection.
a couple of things happened, both Gardner, the development of groups. I would argue as well, culturally, Kramer versus Kramer was the watershed moment in
Yes.
the popular consciousness,
Yes.
where divorce became something prior to Kramer versus Kramer.
Right.
Divorce was for wealthy people, in the same
Right.
way that you have will contests or for people
Right.
with large estates.
Right.
And after that, it became something that was, a middle class. Everybody has to deal with divorce now. And the law firms have created the cottage business that in family law and matrimonial, and even in post-divorce decree litigation about child custody and contempt and ex parte orders, all this stuff has created a cottage
Richard,
business.
more fundamental to that Kramer versus Kramer was the tender years doctrine. And the tender years doctrine stated that mothers have to get full and total custody of children under the age of 5. I believe 5 was and that fathers basically had visitation. They were devoid of any rights to protection of children who were in fact being abused by mothers who were caretakers. There was this automatic definition that all young children had to be cared for exclusively by the mother, and the father had visitation services and huge financial rewards at that point. So the tender years doctrine is the trigger point, not so much Kramer. I mean, Kramer versus Kramer embodied these
I think
issues.
culturally, Kramer versus Kramer was the watershed. I think you're right that from a clinical or from a historical tracing perspective, probably.
And the legal direction.
Now, Theo, I want to go back to you real quick because in your advocacy, you just don't look at the lawyer's bills. You've also talked a little bit about ideas like voir direing your judge, talking about how litigants should be aware of biases and issues with judges. How important is judicial accountability in the push for reform? And do you think that the judges pay enough attention to unethical issues like attorney billing, false claims, or is there a tendency to turn a blind eye from what you've seen?
Right. Yes.
Surprisingly, I've heard many stories of judges actually looking at reports that were submitted and pleadings about overbilling. Surprisingly, some judges would say, yeah, chop that down. I'm kind of shocked because, and it's actually bad for business for me. And I would love for there to be no need for someone like me ever again for what I'm doing now. I would love for attorneys to only bill for the legal advice that they are licensed to provide and not act like a support pet who charges $500 an hour to listen to you complain about that red sweater you had to wear for the Christmas picture for hours and hours, right? They're not licensed to charge for that, right? And but there are some judges. Now, many judges started off in the gutter, the dirtiest part of the sewer of the legal world, which is family court, right? This is where the talentless and soulless stay to make lots and lots of money. And they started off there, and then later on, they climb out of the sewer and they clean themselves off and they get to wear a black robe. And some of them look at some of these cases and say, no, I know that they do this to people. Why are you charging them so much money? This is wrong. Those judges end up on another floor doing all of the pro se divorces. That's like a punishment, right? That's like, these are like rungs of,
That's funny.
purgatory now. And so you'll see the judges that fight back against some of the largest, most predatory law firms. For example, totally different topic, but sort of not. PPP loans. During a time that family law was just booming because of Zoom court, e-filings, because of people being stuck in a house together and saying, get me away from this person. People were wrapped around these family law offices saying, get me a divorce now. Yesterday, I need a divorce yesterday. Okay. There are these family law firms that took massive, look it up in your town, look it up in your county. They took millions of dollars in PPP that was forgiven. Now it's like, well, but see, they were allowed to because they had X amount of employees and blah, blah, blah. And they're just playing the game. Don't hate the player, hate the game. But look at the ethical compass of these people. Look at what they do, which is, hey, if I'm allowed to do it, I'm going to do it. And then the more money they have, I've heard lawyers bragging about how they personally put that judge's butt up on that bench. I don't know if these stories are true or not, but then they show up in front of this judge, and the judge is ready to climb over the bench and like jump on them and start making out with them. And you got to wonder if these stories are true, right? And so then judges will allow these people to do the whole squeeze and dump because, your family's just like maybe, I don't know, like a nice orange, right? You just squeeze all the juice out. And then what's left afterwards is that husk, boom, in the garbage, right? And so there are some firms that are experts at just sucking people dry pre-trial and then dumping them. And then going in front of their favorite judge, whom they put up on the bench allegedly, and saying, we need to dump them now because they're not paying us.
I'll say what doesn't want to be said about that. There's a firm in Chicago named Bierman LLP that Michael Volpe and I have covered extensively, and they kind of fit the bill of that the juicer machine. They like the juice, they juice everybody, and all that's left is the husk. And you see that a lot. And a lot of the most egregious cases out of Chicago and the Illinois area that we get and that we see have Bierman's fingerprints on them in some way, shape, or form. There's also some pretty bad psychiatrists out there and other really bad people in Illinois that would keep on coming up. But Bierman is one that does come up that fits that bill. So, Theo, I'm going to ask you one more question, and then we'll throw it back to Jill. My question for you is, for our audience and the general public, also people that are family court litigants or people that are just being introduced to this and they're searching for what to do. What practical advice could you give to a parent entering a custody or a divorce case so that they don't fall victim to financial exploitation or other injustices?
First of all, try not to go there at all, right? Just do everything, breathe and meditate or pray or whatever you got to do to stay calm and keep your peace of mind. And I would say, again, do whatever you have to do that really truly is in the best interest of the children. Stop thinking selfishly about yourself and all this other stuff. And don't get sucked into the manipulators' games. I've seen evidence of attorneys coaching parents to say and do things that will stir up more conflict. And there was no other reason than to stir up more conflict, to generate more motions, more back and forth between the attorneys, right? So the more you can keep things calm between your soon-to-be ex, your baby daddy, your baby mama, whatever you want to call them, your husband, your wife, the more you can do to keep things calm, that's good. And then from there, maybe start educating yourself on how to read a fee agreement. When you see a bad fee, and I had one person tell me, wait a minute, are you telling me that this fee agreement is possibly not totally legal? And I said, I am not giving you any legal advice. He's like, but it really looks like this whole fee agreement is not totally legal. And I said, he goes, but I got this from a lawyer. how could I be getting something that's not legal from a lawyer? Oh my goodness. Then he realizes, oh, those scumbags. Yeah.
I'll give you an example. I saw a case where the fee agreement calls for arbitration. You can't go to court if the lawyer screws you. You go to court for everything else, but if you say the lawyer's screwing you on fees, then you have to go to arbitration. And the arbitration isn't the AAA or one of these arbitration boards that we recognize. It's a group of local lawyers in the area where the person practices law. And so this flies. This is actually within Connecticut, of all places. But this it's something that's actually being litigated right now. But that's one red flag that I've seen with these arbitration agreements. Who is the arbitrator, number one? If you go to arbitration, you give up rights to go to court, have the full rules of evidence, disclosure, discovery. But that's one issue. But you're 100% right. There are so many potential pitfalls that people have to see when engaging a lawyer or understanding their rights. Jill, I'm going to throw it back to you. I'm going to ask the same question, but in a little bit different way. Your experience and your vast experience, how widespread are these issues of embellished advocacy, for lack of a better term, predatory billing being one of them? How widespread is this? Some argue that there are just a few bad apples in the system, and others say that this is a broader, more systemic problem. Which is it? And what types of concrete reforms do you think can help the family courts?
Well, at this point, 2006, January, we are seeing a systemic problem of fraud and collusion between members of the court-appointed officials, and the attorney population. That this is a process of generations of developing a collateral assault on protective parents for the purposes of transferring funds from the federal government to the states. And it is a collaboration of both court-appointed expert witnesses who work with the courts, are court-appointed by list, and are often inadequately qualified to unqualified, and whose primary arrangement is to support the prefix direction of the courts. This is a systemic process across all 50 states and all jurisdictions. That is my professional opinion, having worked with the courts from approximately 2000 to the present, and very, very intensively.
You've been doing this for a long time. What is the answer? I talk to people all the time, all over the place. Wait, I'll tell you.
Yeah, I have an answer.
I know. I'm gonna lay it out there. Some people say abolish family court. Other people say get rid of all the court appointeds. Other people say let's work in the system and have more transparency. What's the answer from your perspective?
The answer is, first of all, understanding the nature of the problem, the incestuous nature of the problem. That's number one. But what the foundation does is we take case by case, and we examine, analyze, and then integrate the solutions to every single part of the case in terms of exposing the problems. The problem has to do with protecting evidence and being able to present evidence, both in terms of testimony and the authentication of evidence. Those are simply the basic rules of any litigation process. The underlying issues have to do with the ability to present the constitutional principles that protect evidence and due process. Those issues that are should be presented by attorneys, but the attorneys, as far as we're concerned, have massively abandoned their fiduciary responsibilities to clients. The framework of protection of clients' evidence and due process lies within constitutional law and the application of Bill of Rights and constitutional principles. And that has to do with simply, very clearly and very basically, the application of the law, and not and confronting the ability to, in a biased and manipulative and illegal manner, to subvert that process.
I'll
So
tell
it
you what,
has,
Jill.
yeah,
Jill, I'll tell you what, and I've seen some of the work that the foundation has done, especially in conjunction with the Amen Clinic and Dr. S. Gregory
yes,
Hipskin, with respect to brain imaging evidence.
yes.
That's
It's part
actually
of it.
something that I'm so interested in. It's such a phenomenal thing. We have a guy, S. Gregory, Dr. Greg Hipskin. He's, I call him the GOAT, probably the greatest
Yes.
of all time. With what you just said, taking
Yes.
the medical and translating it into the evidentiary. There's something it's called Daubert, the Daubert standard. I don't want to bore people about it, but that's
Right.
the standard by which something that is medical or anything else, it's expert testimony, gets diluted into a way that the courts can accept as evidence. The evidence rules are old and archaic, but they're certain that have to be shown. So you can go and get a great brain scan, but until you have a doctor that can translate it from medical into legal, all it is a really nice picture. And what you've done, with the SPECT scans alone and the Amen Clinic and Dr. Hipskin has given a whole new angle to the family court litigation. You can show traumatic effects. You can show brain damage through the SPECT scans and preserve evidence in a way that, and this is something that's not a controversial science. If you go down the courtroom from the family court and you go to a personal injury case in another courtroom about a car accident, the trial lawyers would be aghast if you wouldn't allow in a SPECT scan related to a car accident to show brain damage, to produce damages. But when you walk down the court back to the family court, you have judges, and you can tell us a little bit about this. We had one in Washington State, one in Oregon, one in the District of Columbia, and in other places where these judges are taking the evidence from someone who sits in the White House Council for Brain Health, and they're questioning whether this is actual evidence. Tell us a little bit about the craziness that we're seeing in these courts.
Well, the structure of the foundation is to involve and support, and also to protect the licenses of legal, forensic, psychiatric, medical experts who have expertise in documenting and protecting evidence and being able to present it. So the foundation has a very small group of very brave, ethical, dedicated individuals, attorney representation as experts to pro se clients. We need to be able to protect the independence of the case by controlling the case through having the client as a pro se litigant. So we are in control of the evidence, the facts, and the entire court process.
So you arm the client with the knowledge and the ability and actually the resources, the people that can get their case presented correctly and protect it. Is that what you're saying?
We protect the integrity of the case on every front by providing the mechanisms, the legal mechanisms, the legal process of litigating, prosecuting, and pursuing damages in these cases via experts, legal, psychiatric, forensic, medical experts that can then put the case together, not dealing with hearsay garbage as is presented by fungible evidence in psychological testing, which provides insight into therapy situations, and in many situations done properly, but does not reach the evidence level, the ethical evidence level of a trial.
And so, Jill, one of your ethical experts is Theo Chino, who's here. Yes. He comes in the billing.
Yes.
And tell us a little. First, I'll ask you, Jill, how does he fit into this matrix? And then I'll ask Theo exactly what someone who's a litigant might expect. So tell us, how does he fit in with all the other experts?
Well, Theo is the bedrock. It gives us insight into the legal unethical practices being that we can, on a very solid level, trace, document, and put meat on the bones. There's nothing fungible or arguable about it. It's very black and white. Somebody has either put in the time, has either met with certain people, taken certain steps, or they haven't, and that is reflected in the billing. There's also, the interactions and the biases are also able to be interpreted in the billing, further understood in terms of looking at the hardcore facts and the fabric of the billing. So Theo is a bedrock of information in terms of looking at every case, whether it be Jones Day, which is the largest law firm in the world, Bierman, private practitioners, the Nussbaum in the Ambrose case. All of these people are presenting hard evidence, and what we need, just as the brain scans, Theo's work is the financial brain scan of our work. So
Theo,
everything that we do.
I want to ask Theo real quick. Theo,
yes.
when we tell you if you want to get to the bottom of something, you
yes.
follow the money. Theo,
that's right.
How do you follow the money? Tell us a little bit about what you do, Theo.
Well, I don't want to call anybody anything until, I just ask questions, and I love to hear their answers. I love to hear people brag about themselves. And what I see in this realm of the law, which is funny because somebody went to the courthouse and said, wait a minute, we're not in the law division now? I thought this is court. Like, that other one is not the law division. And so when you see the incompetence, like 99% of family law practitioners give the rest a bad name. Right. So what I see is I actually see some people who are ethical, who they have their own set of ethics, which is kind of a problem, but they have ethics and they have morals and they care about their clients. They at least don't want to do any harm. They are also terrible at billing. They actually shortchange themselves. I've seen good attorneys. I've helped good attorneys actually resolve gaps in perception of how much they should have gotten charged. And I've actually helped good attorneys get to a better spot where they can feel confident to ask for money from their former clients. I think a good question that everybody who's about to step into this family court, let's call it family court land, is maybe they should ask their attorney, have you ever sued one of your former clients, and why? Have you ever been sanctioned? Have you ever been suspended? Right? And there's a guy out here in Illinois who was forced to represent his client. He wanted to do the squeeze and trash, and he wasn't allowed to. So this guy doesn't have anything between his ears. He couldn't try a case if his life depended on it. So he calls his client up to the stand and says, can you state your name and spell it? And as soon as she's done doing that, he goes, we rest our case, and just lets her get destroyed by the opposing side. And this person has been suspended recently. I don't know if for this or for something else, but these are the kinds of things you should know. Like, there are some father's rights attorneys. If you look up the official laws, there is no such thing as father's rights. This is a marketing thing, right? And again, I am not giving legal advice. Should there be father's rights? Sure. There's nothing actually spelled out in the law like that, but they market themselves as a father's rights law firm. Did you know that some of these law firms charge for investigative services that were never performed? And even super traumatized people whose lives are being destroyed are able to spot it and ask for their money back. Did you know some of these law firms actually in their fee agreements say, if you don't complain about anything on this bill within 5 days of receipt of this bill, it's too late and you can't complain about it? Is that legal? I mean, I just ask questions, right? And a lot of people are like, they're so freaked out and scared that they're never going to see their children again, that they're like, just give me that piece of paper. I'll sign anything. I'll pay you anything. I just want to like not lose my kids. And they don't understand how if there wasn't anything extreme going on, there was no evidence whatsoever of anything bad, any kind of emergency or danger going on, how their kids could be slid onto this table that's being used to chop up all kinds of things like their assets and their equity. And of course, you know, one for me, and it's in the best interest of the children, the attorney's children who need to go to private schools, who need to drive fancy foreign automobiles because they don't want to be embarrassed being dropped off at their private school, whose children are probably soulless and talentless just like them. So they need the money. So this is about the best interest of the children. And it's one for me, one for you, one for me, one for you over there. And the families end up like Poland right before World War II. But instead of, I'm not a big fan of those allegedly cavalry charges going straight at the Panzers. That didn't work out so good. But what happened by accident was somebody actually damaged the tank treads of the Panzers, from what I hear. And these Panzers were immobilized. And then a brave cavalry soldier could just trot right up next to that disabled tank and slide a grenade right down its snoot. And you had a bunch of dead Nazis inside that tank, right? So this is where, again, if you slow them down and you make them answer questions and you turn that spotlight back on them and you say, can you please explain why you billed 3 hours to draft this motion? And by the way, we have other ways and other things we can ask for that I won't go into detail here because it'll be boring for you until you care. And we have other ways to verify whether or not they really spent 3 hours drafting that motion.
So Theo, thank you for that. We're gonna close up now. I'm gonna give you, if somebody wants to learn more about you, Theo, what are the ways to learn about you? What are your websites and details?
Best way to get a hold of me is to find me on LinkedIn. And then you can also, it's still under construction, but you can go to billingassetrecovery.com. What I do is not necessarily just related to family law. I just happen to find that probate and family law practitioners are, I don't even know how to put this. It's almost like they're making my job really easy, if you know what I mean.
Yeah. Okay. And also you can reach Theo through Jill Jones Soderman at the Foundation for the Child Victims of the Family Court. And if somebody has questions for you, Jill, or they have a family court matter, how do they get a hold of you?
The website is FCVFC, Foundation for Child Victims of the Family Courts.org. And there's, you can call us 24 hours a day, 7 days a week. The phone number is 866-553-6931. I just also want to add that the foundation, our basic theory, our basic philosophy deals with equal rights for parents. The tender years doctrine was spawned the reaction in terms of fathers' rights because of an imbalance of rights that are given to both parents, that we're looking for protective parents, men and women, and equal rights under the Constitution. And that's what our foundation is about. So we don't have a bias in terms of men or women. It is simply the application of constitutional law under the work of scholarly legal experts and medical, forensic, psychiatric experts. And under my direction, I'm the forensic expert and a psychoanalyst by training and experience for many, many years. And our work is to protect children and to advance the causes of all parents and of society, because society is at risk from the genocide that has been taking place since the early 1980s, and the destruction of families and the murder and suicides of both children and protective parents, men and women. So this is a united front on behalf of constitutional law and protection of democratic society.
Jill Jones Soderman, Theo Chino, thank you so much for being here. and we'll have more for you on this later on. Thank you so much.
Thank you all.